heard on the issue of whether or not he has waived his attorney-client privilege. And third, I will appoint a special master to examine the seized materials, to examine them, seal them, and wait for the court's instructions for their disposal or delivery. And that's for the purpose of protecting Mr. Durst's privileged communications and the privileged communications of others and core work product. That hearing, the hearing on privilege and waiver might be set on the same date that you're calling for another hearing?
Yes, Your Honor. Just with respect to the court's ruling.
Yes. And in particular, let me state there's a proposed order that asks that I find that there is waiver. I will strike that paragraph. That's paragraph 2, and strike it in its entirety.
With respect to the special master, Your Honor, we're requesting that the special master, in addition to separating out any privilege materials, they need to separate out privilege materials that are privileged for Mr. versus people, or else, depending on the court's ruling, we'll have to do that again, and I think they can probably expedite it with the court's permission.
Thank you. So I will write the order appropriately, amend the order that you proposed. You've noticed a conditional examination for a witness, and you have proposed that this take place on Valentine's Day, February 14th. Is that date suitable, Mr. Chesnoff?
Thank you, Your Honor.
Yes.
Court, Your Honor. I want to put this whole idea of conditional witnesses in perspective for the court before we determine a date. Initially, the people had informed us that it was their intention to do these conditional witnesses in conjunction with the actual preliminary hearing. And they indicated to us that they would then be videotaping the preliminary hearing so that we would have a record of their conditional witnesses. At some juncture, the people informed counsel, not me, but other counsel that they're talking to, that they intended on having about 8 or 10 conditional witnesses, and they named 2. As of this juncture, Your Honor, we're not sure we even have the discovery that applies to the proposed conditional witness that we just received notice of last evening in a formal way. The court knows from looking at the statute that the 3-day notice is a notice that's kind of like a statutory order of time. It's not, we're going to do conditional witnesses and then we can do them in 3 days. We have to put this in context for her. There are tens of thousands of pages of discovery. This juncture, obviously we haven't proceeded and reviewed all of it. Witnesses are going to be filmed. In the event they're not available for trial, the people want to go to trial. The court commented when the court first came out about its concern for Mr. Durst's rights, and there are many rights that are implicated. He has a right to effective assistance of counsel, which will clearly be impacted by our inability to conduct this conditional examination without the benefit of having reviewed all the discovery in the case to see where that particular witness fits within the dynamic of the prosecution. It also implicates Mr. Durst's right to his own review of the discovery with his counsel prior to any examination occurring. Your Honor, because the examinations involve confrontation and cross-examination, which to a citizen accused of a crime as serious as this are absolutely the most important rights that that person has. And at this juncture, without even knowing the identity of others, without really knowing whether we have the discovery, for example, for this Mr. Cooperman, or Dr. Cooperman, I apologize, without having an opportunity to integrate the other discovery with whatever does apply to Dr. Cooperman in terms of our theory of defense. We haven't even heard the prosecution's theory of prosecution yet. They're asking us to conduct a cross-examination that will be recorded, that potentially could be shown to a jury, without ever giving Mr. Durst and his lawyers an opportunity to fully and completely prepare. We are confused as to why there was a change between the idea of doing this, at least at the date of the prelim, when we've had a chance to seriously review discovery. I don't want to be repetitive because that's a bad habit of a lawyer, Your Honor, but I cannot emphasize enough to you how much discovery there is. It is time-consuming. We are working literally around the clock to review material, but as an officer of the court, on behalf of all the defense lawyers, Your Honor, we want the court to know that we could not possibly be prepared for a conditional witness and provide Mr. Durst that he needs. We have plans, Your Honor, within a week to file a pleading about this issue so that it'll be fully briefed. The people can have a chance to respond. The court will recognize that Penal Code 1335 and the rest of the sections that follow
The joy of creating, the joy of giving. Pandora Jewelry, hand-finished
everybody's
sterling
had the
silver.
chance to see discovery. There may not be tens of thousands of pages. And I want to add another point, Your Honor. Mr. Durst was arrested in New Orleans based on a warrant sought by the DA here through the LAPD. Since his arrest in New Orleans, defense counsel has repeatedly requested that we receive the LA discovery to get started even while we were there. The people take the position that they weren't entitled to give us any until he made an actual appearance here. So we want the court to know that we were not dilatory and at least trying to be in a position to be more prepared than others might be. We understand that that's the policy of the LA District Attorney, but we wanted the court to know that we have been trying to do this. So we're not trying to do anything for purposes of
The joy of creating, the joy of giving. Pandora Jewelry, hand-finished sterling silver.
Counsel. It's solely so we can cross-examine and confront these witnesses. So the position is, Your Honor, that February 14th is premature. We're going to file a pleading with the court, which the people will be able to respond to, and the court can hear additional argument. But that's our position, Your Honor.
Okay, thank you. People?
I just want to correct a couple of things that are important. Back on June 3rd, I sent for counsel indicating that our office had sought an early penalty determination so that we would be able to conditionally examine in this case. I've had repeated conversations with Mr. Lewis, Mr. Ray, where I've explained to them that depending on when the preliminary hearing was going to take place and depending on issues such as the age and health of witnesses and security of witnesses, that we were going to be doing conditional examinations. In that letter of June 3rd, I specifically stated we would be doing conditional examinations. I think Mr. Chesnoff is not understand he's not a California lawyer, but honestly, Your Honor, we would not do a conditional examination at a preliminary hearing. We would do a preliminary hearing.
The creating, the joy of giving. Pandora Jewelry, hand-finished sterling silver.
On a preliminary hearing. So the first issue would be that we have been very clear to them that we can individuals. The second issue, and this is very important, Mr. Durst is accused of the murder of one witness. He has admitted to causing the death of a second individual who we killed because he was well. And the special circumstance in this case is that he murdered his wife. Two of those three individuals, the people are alleging, were murdered because they were witnesses. Mr. Durst has something in the order of $100 million. Witnesses in this case, realistically, understandably, are concerned about their safety. For that matter, for that reason, Your Honor, as the court is aware, we came in and we had an ex parte hearing with the court where we explained the process and the procedure that we wanted to utilize in terms of discovery in this case. I want to talk about Dr. Cooperman first. Dr. Cooperman's discovery has already been provided. It consists of, in essence, 2 interviews with the people, one very short. They're tape recorded, they have, and the second is an interview which they have a transcript of from the filmmakers. Dr. Cooperman's part in this case is very simple. It is alleged, I don't know if the defense is going to stick to this theory or not, but in the media it has been portrayed that Dr. Cooperman received a call from Kathy Durst the Monday, February 1st, after she disappeared. The discovery makes it very clear that Dr. Cooperman believes that Kathy Durst called him because the person identified themselves as Kathy Durst. That becomes extremely important in terms of when she was alive. And Dr. Cooperman is, he's a very young man of 86 in January. Although he seems to be pretty healthy and pretty spry, it is very important that his testimony be preserved. Now, even though we did not have to, we told the defense, now roughly it'll be 2 months advance notice that they were going to be, we were going to be conditionally examining Dr. Cooperman. I got a call over the weekend from Mr. Lewis. Mr. Lewis said, hey John, can you please email me how many interviews were with Mr. Cooperman? Can you email me the transcript? Can you email me the audio? And I did. A very good relationship with Mr. Lewis, and certainly could have said, hey, it's in the discovery, I'll go find it, and we sent that to them. So with respect to Dr. Cooperman, you have 4 extremely capable lawyers, and there are other lawyers.
Looks like 5.
That they grew on me.
4.
You're right. They've spawned more.
Which one is not? Never mind.
Oh, you're trying to set me up now, Your Honor. I'm not taking that bait. So the bottom line is you have very experienced lawyers. They have more than ample time. I'm sure the court is aware of this, that obviously a defendant has a right to preliminary hearing within 10 court days. The people also have speedy trial and speedy preliminary hearing rights. To give them 2 months for Dr. Cooperman is beyond anything anyone that could be required. The second issue and the second individual that's going to be conditionally examined. We came in under the authority that is granted to us under 1054.7. We came in and we had that same ex parte hearing with this court. This court was presented with the reasons why we wanted to delay the name of the witness and the discovery of this other witness until 2 weeks prior to preliminary hearing. I'm sorry, to conditional examination, thank you. The court heard our rationale. The court was very clear that absolutely it made sense, and the court agreed that we could go with this procedure. We then, Your Honor, not at the court's suggestion, not because we were required to, we then made arrangements to come back a second time and to say to the court, Your Honor, is it okay with the court if we notify the defense not who the witness is going to be, but at least that it's someone they don't have discovery for and what those dates would be? We've been asking the defense, and they received these documents from us, this information, more than 2 weeks ago. We've been asking them to tell us what is a convenient date. I understand everybody's busy. We're busy. I talked to Mr. Ray last week. We had a deadline of last Friday in the letter that we had sent them. And we made it very clear. If you pick a date, you're not in any way waiving your rights. You're simply saying if the court goes our way, and the court has already agreed, what's a convenient date? Mr. Ray said, listen, we'll have all the lawyers here on Wednesday. Can we do it then? We said fine. In the interim, we have, in discussing the situation with witnesses and with law enforcement and the time that's involved, we are picking the latest date. That would be February 14th. Our plan is, with the court's permission, is to conditionally examine Dr. Cooperman first. I have related to, Your Honor, the entire scope of Dr. Cooperman's testimony relates to that phone call and a little bit about his relationship with Kathy Durst who was a student that he hardly knew at all.
What a Christmas day.
The second witness, and again, we are not giving that name. The
Snow
second
is
witness
gently falling.
The joy of creating,
that has
the
very
joy of
important
giving.
information,
Pandora
and that
Jewelry,
we've made a
hand
proper
finished
showing to the
sterling
court
silver.
that necessitated in the court agreeing to that 2-week limitation on when the evidence be provided. I want to say something that's extremely important, which defense counsel is not addressing. The only way that these conditional examinations will be utilized is if a witness becomes unavailable. With respect to Dr. Cooperman, that is likely going to be because he passes away due to age, he becomes too infirm, etc. If we do not do the conditional examination, we cannot go back later and figure out what, if anything, he would have said. The second witness, and this becomes very important as the defense talks about their due process rights, there is one way and one way only where this will become an issue. That witness, Your Honor, would come and testify at the conditional examination. They would, subsequent to that, have to either disappear, die, be murdered, etc. And at that point, we would be coming in saying, Your Honor, it sure is a good thing that you schedule these conditional examinations, because that witness's testimony would be lost forever. So despite the protestations about due process rights, etc., Mr. Durst's due process rights will not be unless we attempt to utilize those conditional examinations, which, as the court is aware, can only happen when these witnesses are unavailable. So we are asking today, Your Honor, and the court is aware of some of the logistical issues which I cannot get into, I cannot discuss today. The court is aware of them. We need to have a determination that the conditional examination is scheduled for the dates that we've indicated because of the precautions that we have put on the record with respect to that other witness. So, in summary, we are requesting to do the conditional examinations on February 14th. We will start with Dr. Cooperman because he is going to be a much shorter witness. That gives us, gives the defense plenty of time, gives us plenty of time for direct and cross-examination. The court, we've already, as the court's aware, we've already discussed these dates with the court. And so we're requesting that today the court make that order.
All right, thank you. The,
Judge?
yes, Mr. Chesnut.
Thank you, Your Honor. Your Honor, the reason that the statute says you get 3-day notice is so that you can have an actual hearing. This is kind of an impromptu hearing that we felt compelled to inform the court that we plan on filing pleadings. I would ask you, Your Honor, before you make a finding on the date or the propriety of it, you read our pleadings. That way we'll be complying with the authority. Your Honor, I understand that when somebody comes to you ex parte, that's not of your choosing, that's of their choosing. Defense counsel a little confused as to why something like this, rather than being the subject of a motion, was the subject of an ex parte. Mr. DeGuerin wasn't present, Mr. Lewis wasn't present, Ms. Bain wasn't present, I wasn't present. And I will tell you, Your Honor, this kind of inflammatory discussion about people being killed, other cases that the state presumes are going to be part of this case, we haven't litigated motions in limine, the propriety of whether anything in New York even comes into this case. The case in Galveston, Your Honor, was an affirmative defense of self-defense. A jury made a finding of not guilty. For Mr. Lewin to presume to replace the good judgment of 12 people in Galveston, Texas, with his own interpretation of what happened is exactly the kind of presumption that allows somebody to release a tape to the media about an interview he did because he's concerned that we're accusing him of something that he did wrong. Defense lawyers accuse the police and prosecutors constantly of making constitutional mistakes. It's not a personal attack, Your Honor. It's an attack to protect the rights of Mr. Durst. What Mr. Lewin is doing by inflame the circumstances by suggesting that a man in a wheelchair is somehow a threat to an 85-year-old doctor living in New York, when none of the allegations in any of these cases suggest that anybody has ever been involved but Mr. Durst, is just hyperbole, Your Honor. I'm asking you most respectfully, hold off on ruling until you see what we write about the issue of conditional witnesses. And by the way, what Mr. Ray said to Mr. Lewin was the following. We are opposing this. We are going to file a pleading. If the for some reason doesn't agree with us, I will talk to my colleagues about appropriate dates. Mr. Lewis or Mr. Ray never acquiesced to this. They do have the ability to speak to Mr. Lewin, which is not available to all, but that was not what was said. We cannot impress upon you enough, Your Honor, that it is important that we have an opportunity to read the discovery in this case before we start litigating.
Thank you, Mr. Chesney.
Thanks, Your Honor.
All right, first of all, I think it's useful to, for me to read 1054.7 of the Penal Code pertaining to discovery. If the material and information becomes known to or comes into the possession of a party within 30 days of trial, made immediately, unless good cause is shown why a disclosure should be denied, restricted, or deferred. Good cause is limited to threats or danger to the safety of a victim or witness, possible destruction of evidence, or possible compromise of other investigations by law enforcement. Upon the request of permit a showing of good cause for the denial or regulation of disclosures or any portion of that showing to be made in camera. A verbatim record shall be made of any such proceeding. If the court enters an order granting relief in camera, the entire record of the showing shall be sealed and preserved in the records and shall be available to an appellate court in the event of an appeal or writ. In its discretion, the trial court may, after trial and conviction, unseal any previously sealed matter. And this applies to both parties. Certainly, you may be in a position to also to seek such an order from the court deferring discovery. It is within the scheme of discovery under 1054. So, such a showing was made in court. Such a record was made. Mr. Chesney.
So just a question. Does
I take these as synonymous here. Recognize that many times the reason for it is privileged. I'm not sure it's a privilege here, but I believe that that's true. Certainly, it's true from a defense. You have the reveal. Yet you could go in camera, and I would treat that in camera. So the court proceeded. I believe the case law supports that idea. A showing was made to me that it ought to be in camera, and permission for delayed discovery. As to the witness, it appears you have a discovery already. That's what's described. A context for, I understand that this other witness revealed to you nor the discovery regarding that. But in the universe of material, you have nearly all of it. So it wouldn't seem reasonable to conduct a conditional exam on the 14th. Now, that being said, I don't know why a notice was only given. I would have liked to see the brief now, and of course I want to hear what the defense has to say about this. I mean, I don't see why it's reasonable, but perhaps I ought to make it a tentative pending a hearing on whatever objection there might be. Mr. Lewin?
You know, the reason a date was not, when you're saying notice of a date was because at we sent out a letter to him approximately December 4th.
I thought that was pertaining to the unknown witness, hearing from Mr. Cooperman, who witness.
Well, so here's what we told them. We intended to do both examinations, and then what Mr. Ray me was I repeatedly the week that it was due, and I was working and busy, and he needed to coordinate, and he said, can we discuss it on Wednesday in court, which is today? That's why we don't have a date. I informed them of this February 14th date more than a week ago, and I asked them why that date was going to be the appropriate date. I explained that to Mr. Lewis and to Mr. Ray. And that is why, Your Honor, we didn't notice the date, because it was at their request.
All right, so now I'll read a response, and we'll have another day in our court discussing the timing of this examination. So perhaps you could confer amongst yourselves about, and with our clerk, about an appropriate date for hearing of any objection to this. Perhaps we would fast forward the other issue we have, and that is the issue of whether or not there was a waiver of attorney-client privilege. I'd like to take care of more than one issue in one day.
Your Honor, this would be the people's request. We request that the court right now, because of the logistical issues the court's aware of, that we schedule the conditional examinations for February 14th. Obviously, should the court decide for whatever reason that that is not going to take place, then the court would certainly be able to cancel it. We're going to ask that the court schedule it for that date, and then in the interim, when we litigate, and we're ready to litigate both the issues, both the waiver issue and the conditional examination issue, as soon as possible, we can pick out a date now.
You go ahead and do your scheduling. I mean, it seems to me that it is sufficient time. Yet I haven't heard the objection, okay. And I'll give. I like it to be written and descriptive of the facts at issue. So we'll give you time for that, and you can cancel it if it's not appropriate to have a conditional examination on February 14th.
I think the issue that we just wanted to get straight today is we understand they're going to be objecting. What we're looking for, and I've repeated this to both Mr. Lewis and to Mr. Ray, is we understand you're going to object, but let's pick a date so that if it ends up happening, we're in agreement. Let's not litigate it and then pick a date. We need to have a date set because of the court schedule and because of the logistics involved. So we're requesting the 14th.
May not have been a meeting of the minds. So who shall I recognize, Mr. Ray? You're local counsel. Do you trump Mr. Chesnoff, or do you defer to Mr. Chesnoff?
Me for years. Go ahead,
Just a couple of things.
Yes.
What we are talking about, we are going to object. We will file a pleading with the court. I think we have to pick a date that's convenient to the court. That's what we've been holding off on for that hearing to be had. If in fact it goes forward, we indicated we would try to settle on a date today. We can talk to counsel, make sure the 14th is a good date. It appears to be everybody that will be a good date if in fact we're going to proceed. So the court can set the 14th as the date, assuming that we're going ahead. I will be filing a motion by Friday, indicate to counsel with regard to whether we should actually be going ahead at all, and those are the pleadings that the court was talking about. We are interested, obviously, in litigating all the issues that the court was talking about, the part of this case, which of this hearing, to suppress on the issue concerning the events. Quite honestly, we are not prepared to file those motions at this point because we've been spending an inordinate amount of time trying to catch up with regard to the discovery, because we have gotten more discovery in this case than I think I've ever seen. And I don't know if megabytes or gigabyte ever is up there. So what we would ask the court is we would file the motion with regard to the conditional examination. We would like to set a date for that, and I think counsel wanted it to be before the 4th of January.
Yes.
It's the 3rd, Robin. Robin has to say on that. We have it.
That'll be a great day back from vacation. Okay, the whole day.
Is the 4th available?
I think that's even worse. Let's see. 6th.
Sick.
Can I start steering you to Fridays? We're actually a trial court. So we're often engaged in trial, and these hearings seem to take more time than I would have imagined.
Your Honor, I don't think any counsel ever told the court this case would be quick or would not be inconvenient.
The 4th suitable for everyone?
It's in the 4th or the 6th, Your Honor.
Pardon? What did I say?
I thought you said
6th. 6th. Yes.
What time on the 6th, Your Honor? Does the court want us here?
10?
No, he doesn't mean want us to.
Okay. All right, 10 o'clock.
10 o'clock. And Your Honor, just so we're clear on the purposes of the motion, it's my understanding we can do the waiver. We discuss the conditional examination.
No, all we're talking about is the issue of whether we should proceed with regard to the conditional examination. The waiver issue is going to require, I think, a full evidentiary hearing, and we are not even begun to file, we're not even ready to prepare and file a motion with regard to that at this time. So we are asking that it be limited to the issue of the propriety of the conditional examination.
Sound all right to you, Mr. Lewin?
Your Honor, I was merely that the court had said the court wanted to take care of more than one issue at a time.
I'll defer to counsel.
I
I want
was
you to do
simply-
your jobs the way you see fit, so that's fine.
We're ready to go. If the court wanted to argue waiver, conditional examination, we're
Yeah, right. No, you've in fact made an argument. So
We very much appreciate the court's consideration.
then, does that conclude our business?
court give us a time on the 6th?
10 a.m.
Oh, 10.
10
Okay, I'm
o'clock.
sorry. In the a couple of other issues, Your Honor, very brief.
Can I have one moment?
Yes.
Okay. I think that's easy, Your Honor.
What time on the 14th were we set? Was that 10 a.m. as well?
Should we always have them at 10 a.m.? 14th, yes, because we'll have, well, it'll be a conditional exam. We're bound to have calendar. It's 10. Right? Is that earlier?
Everything is in my camera.
Yeah. Yes, 10 o'clock.
Your Honor, and on that date, on the 14th, subject to any additional orders from court, will provide, and we'll have a videographer here to videotape the conditional no intention. And obviously, what we do is we give the original goes to the court, we make copies for the defense, and obviously, should they have to be that is.
Yes, Your Honor. Proposed protective order relating the disclosure, regulating handwritten evidence in this particular case.
This is evidence that you're turning over that was
This
a product of the
hit the ground
film,
running.
The film.
Yes.
Any problem with that? Limiting it?
In fact, we'd like to have a universal protective order on all the discovery. It's a little late after the barn door, closing the barn door after the horse is out, but we think that. There's more horses. I don't think that the discovery ought to be put out in the public before trial.
Well, the protective order is limiting the use of certain evidence to these proceedings. It's not saying how we can or cannot use the evidence in these proceedings. So I don't. His comment about
Any further,
barns and
any further protective orders, of course, you're free to file a motion requesting such.
Thank you, Your Honor.
Protective order.
Thank you, Your
Thank
Honor.
you, Your Honor.
Did you make it
It's the orders.
just the order about the courthouse? Okay. Further before we adjourn until January 6th?
One last thing, Your Honor.
Yes, Mr. Ray.
Have a nice holiday.
Thank you. You too.
So, we accept